Hi, everybody. I'm Srinivasan, General Counsel. Would like to talk about the Indian copyright law in India. Indian copyright law is governed by the Copyright Act 1957, which has undergone amendments which protects the rights of creators, ensuring that they receive recognition and financial benefits for the work. It covers various forms of expression, including literature, music, audio, cinematography, films, architectural works, and software, safeguarding both published and unpublished works. Copyright protection generally does not extend to the works within the public domain. Ideas, methods, titles, names, phrases, common property, including public factual details, etc. Copyright is automatically granted upon creating a work, meaning no registration is required, although registering can strengthen legal claims. Copyright typically lasts for the creator's life plus 60 years, after which the work enters the public domain. It's crucial to understand the concept of fair use, which allows limited use of copyrighted material without permission for purposes like criticism, comment, news reporting, teaching, or even research. However, this can be a gray area, so it's essential to tread carefully. Copyright refers to the exclusive legal rights granted to creators over their original works. This includes literature, music, art, films, and software. In essence, if you create something, copyright law gives you control over how it's used and shared. Moreover, copyright is not just about protection, it also grants creators the right to earn from their works. They can license their creations, ensuring they receive compensation for their efforts. Infringement of copyright can lead to serious consequences, including fines and legal action. Creators can take action against unauthorized use of the original work. So, awareness of copyright is important for both creators and users. It is essential to respect creators' right and seek permission before using their work or the work resembling them. There is no copyright in the ideas of an author. Thus, copyrights subsist only on the material form in which ideas are expressed. Copyright protection is not granted when the work is illegal, immoral, against public policy, if it is defamatory, seditious, and created to defraud the members of public. Rights bestowed by copyright includes the right of publication, whether to publish or not, the right to claim authorship of a work so published, the right to prevent alteration that may disparage the author, the right to initiate proceedings seeking injunction and or damages if modification of the original work of the author is going to be prejudicial to the author. These rights remain with the author even after the transfer of copyright. Yes, it extends even after transfer. The following acts constitute an infringement of copyright. This is very essential to know what infringes. Making infringing copies for sale or hire, or selling or letting them for hire of original work. Permitting any place for the performance of works in public where such performance constitute infringement of copyright. Yes, I should not allow my premises. Distributing infringing copies for trade or to such an extent so as to affect prejudicially the interests of the owner of copyright. Public exhibition of infringing copies by way of trade and importation of infringing copies into India may be classified as infringement. The following acts do not constitute an infringement of copyright. For example, a fair dealing with any work not being a computer program for private or personal use, including research, criticism or review, whether of that work or any other work, the reporting of current events and current affairs, including the reporting of a lecture delivered in public. To make backup copies purely as a temporary protection against loss, destruction, or damage in order to utilize the computer program for the purpose of which it was supplied. B. The transient or incidental storage of a work or performance purely in the technical process of electronic transmission or communication to the public. Transient or incidental storage of a work or performance for the purpose of providing electronic links, access, or integration where such links, access, or integration has not been expressly prohibited by the right holder. The reproduction of any work for the purpose of a judicial proceeding or for the purpose of a report of a judicial proceedings would not constitute. The reproduction or publication of any work prepared by the Secretariat of a legislature exclusively for the use of the members of that legislature would not amount to copyright violation. The reproduction of any work in a certified copy made or supplied in accordance with any law for the time being in force would not be classified as an infringement. The reading or recitation in public of reasonable extracts from a published literacy or dramatic work would not constitute infringement. The publication in a collection mainly composed of non-copyright matter bona fidely intended for instructional use and so described in the title and in any advertisement issued by or on behalf of the publisher of short passages from published literary or dramatic works not themselves published for such use in which copyright subsists by a teacher or a pupil in the course of instruction would not constitute infringement of copyright. The performance in the course of the activities of an educational institution of a literary, dramatic, or musical work by the staff and students of the institution, or of a cinematographic film or a sound recording, if the audience is limited to such staff and students, etc., would not constitute an infringement. The causing of recording to be heard in public by utilizing it would not amount to an infringement. The performance of a literary, dramatic, or musical work by an amateur club or society, if the performance is given to a non-paying audience or for the benefit of a religious institution, would not constitute infringement. The reproduction in a newspaper, magazine, or other periodical of an article on current economic, political, social, or religious topics, unless the author of such article has expressly reserved to himself the right of such reproduction. The storing of a work in any medium by electronic means by a non-commercial public library for preservation, the library already possesses a non-digital copy of the work, would not amount to infringement of copyright. The making of not more than 3 copies of a book, including a pamphlet, a sheet of music, map chart, or plan, or under the direction of the person in charge of non-commercial public library for the use of the library if such book is not available for sale in India. The reproduction for research or private study or with a view to publication of an unpublished literary, dramatic, or musical works kept in a library, museum, or other institution in which the public has access would not amount to infringement of copyright. The reproduction or publication of any matter which has been published in any official gazette, except an act of a legislature, etc., would not amount to infringement of copyright. The production or publication of a translation in any Indian language of an act of a legislature and of any rules or orders made thereunder would not amount to infringement. The making or publishing of a painting, drawing, engraving, or photograph of a work of architecture, or the display of a work of architecture would not amount to infringement. The making or publishing of a painting, drawing, engraving, or photograph of sculpture or other artistic work, if such work is permanently situated in a public place or any premises to which the public has access, would not amount to infringement of copyright. The inclusion in a cinematograph film of any artistic work permanently situated in a public place or any premises to which the public has access would not amount to infringement. The use by the author of an artistic work where the author of such work is not the owner of the copyright therein of any would cast, sketch, plan, model, a study made by him for the work would not amount to infringement. The marking of three-dimensional object from a two-dimensional artistic work, such as technical drawing for industrial application of any purely functional part of a useful device, would not amount to infringement. The reconstruction of a building or structure by the architectural drawings or plans by reference to which the building or structure was originally constructed in relation to a literary, dramatic, artistic or musical work recorded or reproduced in any cinematograph film, the exhibition of such film after the expiration of the term of copyright therein would not amount to infringement. The making of an ephemeral recording by a broadcasting organization using its own facilities or its own broadcast by broadcasting organization of a work which it has the right to broadcast would not amount to infringement. There are civil remedies available for copyright infringement. A copyright owner can take legal action against any infringer who infringes the copyright in the work in the designated district court. This is a civil proceeding. The copyright owner is entitled to remedies by way of injunctions, damages, and accounts. There are criminal remedies and punishments for a criminal offense under the Copyrights Act or the Copyright Law. The minimum punishment for infringement of a copyright is imprisonment for 6 months with the minimum fine of rupees 50,000. Underline the word, the minimum fine. In case of a second and subsequent conviction, the minimum punishment is imprisonment for 1 year and a fine of rupees 1 lakh. Any police officer not below the rank of sub-inspector, an ordinary sub-inspector, if he is satisfied that an offense in respect of the infringement of copyright in any work is being or is likely to be committed, seize without warrant all the impugned copies of the work and all plates used to make infringing copies of the work wherever it is found, and all copies and plates so seized shall as soon as practicable be produced before a magistrate. No court inferior to that of a metropolitan magistrate or a judicial magistrate of the first class shall try any offense under the Copyright Act. Copyright with respect to businesses. In addition to trademark registration, the business or industrial houses ought to register their artistic work, including their labels, under the Copyrights Act. This registration gives an advantage in the cost, longevity on the usage of the mark, and easy access to the police station to enforce their copyright. Further, it is not out of place to mention that patent drawings can be copyrighted. This gives an edge to the copyright owner, wherein even if the patent comes into the public domain, the drawings will help to have the monopoly or the same. Copyright registration along with trademark registration helps businesses to protect their intellectual property and assert their rights in the market. Thank you for watching this copyright video.